Hello, ladies and gentlemen. Again, bringing you another legal news video. This time we're going to talk about the Epstein case, right? Everything's, oh my gosh, everything is about Epstein now, right? So, the Department of Justice just filed a motion to unseal the grand jury transcripts in the Epstein case. And so, grand jury transcripts, are usually privileged. I mean, they're secret. And the reason for that is because, we want witnesses. The grand jury is, just a group of people that are shown a bunch of witnesses and evidence, and they decide should somebody be prosecuted. And the problem with, obviously if it's not secret, is that then people could be scared to testify. They might, the people that are in the grand jury, the actual jurors, might be intimidated to say certain things or make decisions. And so we say, okay, those proceedings are privileged. They're secret. They're not subject to disclosure except to a very small, close-knit group of people. But there are exceptions. So if you look at the motion that's been filed with the court by the Department of Justice, they say basically it's in the public interest that there's so many lawmakers, there's the media, the public, everybody's asking questions about this, that it warrants disclosure of these transcripts. And if you read the motion, it's only 4 pages. It doesn't really give that much justification. It's and that really, and they don't cite too much case law. There's a little bit of case law in there, but which the implication of that is that this decision is very much discretionary on the judge. The judge could say yes, could say no, and there's not really a hard and fast rule. I'm willing to guess, because remember the answer, I wanted to say the judge has already responded to the motion and asked for more information. And I assume that request speaks to specifics as to whether you're asking for witness information or so the judge is already asking for more information, and we'll have to see the DOJ probably have to file another response to that, but my guess is that the judge will release some information. Remember, everything can be redacted. Redacted obviously means like crossing names out and putting it in black so you can't see it. So I'm willing to guess that for large amounts of information, if the information that's being disclosed is already public, and it's sort of a parroting of public information already, there's not a lot of harm with releasing that. And obviously you could keep privilege the names of victims, you could keep privilege the names of witnesses, you could redact certain private information you don't want to get out. So my prediction is that there will be a release of some information, but the problem is that it could be heavily redacted, and that it ultimately might not show as much as people may want, because again, there's privilege, and so the court's probably balancing that those two competing interests, which is disclosure that's in the public interest versus the need to keep grand jury protections secret. So once we see how the DOJ responds, we can post an update, but that's where we're at now. And thanks for watching. Please leave a like and subscribe. Thank you.